আপনারা দেখছেন ক্রিমিনাল জাস্টিস।
সবাইকে আবারও সাদর আমন্ত্রণ ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি সলিসিটর শাফিউল আজম, প্রিন্সিপাল অফ আজম অ্যান্ড কো সলিসিটরস, এবং আমার সাথে আছেন ক্রিমিনাল লয়ের স্পেশালিস্ট ব্যারিস্টার, আমার কলিগ ব্যারিস্টার জেনেভিভ মস। Being accused of a crime can be extremely distressing. Not only can such allegations severely impact your reputation and livelihood, your liberty may also be at stake. যে ক্রিমিনাল চার্জের মধ্যে পড়া, ক্রিমিনাল প্রসিডিংসে মানে ট্রায়াল ফেস করা, ইনভেস্টিগেশন ফেস করা ভেরি ডিস্ট্রেসিং, খুব আপনার স্ট্রেসফুল টাইম হয় সবার জন্য। If you are facing a criminal allegation, you need access to the best legal representation to defend you. আপনার correct legal representation দরকার। যদি আপনাকে কোনো পুলিশ যদি ইনভেস্টিগেট করে এবং ক্রিমিনাল প্রসিডিং যদি আপনার বিরুদ্ধে শুরু হয়, who can help you protect your reputation, career and family if you are facing a criminal allegation, who can offer you representation at all stages of proceedings from first interview to final trial. যে আপনাকে রিপ্রেজেন্ট করবে একদম শুরু থেকে শেষ পর্যন্ত ভালো মতো। Can I change my criminal defense lawyers? অনেকে আমার কাছে আসে কেসের মাঝখানে অথবা পরে, কোর্টে কেস যাওয়ার পরে, যে আমরা লয়ার চেঞ্জ করতে চাই। এটা সবার জানা থাকা দরকার। If your solicitors are being funded by legal aid, you will have to get the approval of the court for legal aid to be transferred to your law firm, to your new firm of solicitors. You will usually have to give good reasons as to why you no longer want your current firm of solicitors to represent you. আপনাকে কোর্টের পারমিশন ছাড়া আপনি সলিসিটর চেঞ্জ করতে পারবেন না। আপনাকে ভালো রিজন দিতে হবে কেন আপনি চেঞ্জ করতে চান, সেটা কোর্টের অ্যাপ্রুভাল লাগবে। The longer you leave a request to transfer lawyers, the greater chance you have of your application to transfer being refused. যত বেশি দেরি করবেন তত আপনার রিস্ক থাকবে যে অ্যাপ্লিকেশন রিফিউজ হবে, আপনাকে সলিসিটর চেঞ্জ করতে দিবে না। এই জন্য যেটা রাইট সময় হচ্ছে কি, যখনই পুলিশ স্টেশনে আপনাকে ইন্টারভিউ করে তখন তো আপনি আপনার সলিসিটরকে দেখবেন, তার সাথে কথা বলবেন, কথা বলার সুযোগ হয়েছে, দেখার সুযোগ হয়েছে। তখন যদি আপনি ওই সলিসিটরকে লাইক না করেন, তার অ্যাডভাইস যদি পুলিশ স্টেশনে আপনার পছন্দ না হয়, অথবা তার পারফরমেন্স যদি আপনার কাছে আপ টু দ্য এক্সপেক্টেড লেভেল যদি না থাকে, তখন আপনি স্টেশন থেকে বের হওয়ার সাথে সাথে, অথবা পুলিশ স্টেশনে যদি আপনাকে বেইল না দেয়, তাহলে আপনার বন্ধু বান্ধব আত্মীয় স্বজনকে বলতে হবে, সাথে সাথে কেসটা কোর্টে যাওয়ার আগে আপনি লয়ারকে চেঞ্জ করার চেষ্টা করবেন, আরেকজন লয়ার এনগেজ করার চেষ্টা করবেন, যে আপনার হয়তো স্যাটিসফ্যাক্টরি লেভেল অফ সার্ভিস প্রোভাইড করতে পারবে। সেটা তখন আপনার কোর্টের পারমিশন আর লাগবে না। এই জন্য যখনই পুলিশ স্টেশনের মধ্যে ইন্টারভিউ শেষ হবে, ওই যদি বেইল না হয়, ওখান থেকে আপনাকে আত্মীয় স্বজন বন্ধু বান্ধবের সাথে যোগাযোগ করতে হবে। যদি পুলিশ যদি বেইল দেয়, তাহলে পুলিশ স্টেশন থেকে বের হওয়ার সাথে সাথেই আপনাকে মানে নতুন ক্রিমিনাল ডিফেন্স সলিসিটর, স্পেশালিস্ট সলিসিটর আপনাকে খুঁজে বের করতে হবে, তখন আর কোর্টের পারমিশনটা লাগবে না। I am receiving increased number of queries on sexual offenses. Sexual offenses উপরে আমি খুব বেশি কোয়েরি আমি এখন পাচ্ছি। A conviction for a sexual offense can have life-changing consequences for our clients, and that even minor allegations can result in stigma or a client being forced from their home, especially if they have children. যে সেক্সুয়াল অফেন্সের জন্য যদি কনভিক্টেড হয়, তাইলে এটার স্টিগমা এবং এটার কনসিকুয়েন্স ভেরি সিরিয়াস। Social services may become involved in many cases, and if convicted, the sex offenders register will become relevant sometimes for life. যে সোশ্যাল সার্ভিস ডিপার্টমেন্ট অনেক সময় আপনার ইনভলভ হয়ে যাবে, আপনাকে বিভিন্ন ধরনের অবজারভেশনের মধ্যে রাখবে এবং বিভিন্ন তাদের রুল কানুনগুলো ইম্পোজ করার চেষ্টা করবে, এবং সেক্স অফেন্ডার্স রেজিস্টারের মধ্যে আপনার নাম থাকবে সামটাইমস ফর লাইফ যদি সেক্সুয়াল অফেন্সের জন্য কনভিক্টেড হন। Also, the court will consider imposing a sexual harm prevention order which may have a dramatic impact on the client's ability to associate with certain members of their family. তখন কোর্টে কিন্তু সেক্সুয়াল হার্ম প্রিভেনশন অর্ডারও একটা দিতে পারে, যেটার পরিণাম হতে পারে যে অনেক সময় আপনি আপনার ফ্যামিলির কত একটা নির্দিষ্ট সার্টেন মেম্বার্সদের যদি চিলড্রেন হয়, হয়তো আপনাকে অ্যালাউ করবে না ওদের সাথে অ্যাসোসিয়েট করা, ওদের সাথে বেশি মিশামিশি করা। At all stages, you need specialist criminal defense solicitor to safeguard your interests and to defend your case robustly. In all stage of the criminal proceedings, from the police station up to the trial in the court, you need the specialist criminal defense solicitor to represent you robustly. In the next segment, আমি যেটা বলবো, I will talk on historical sexual abuse. Historical sexual abuse এর উপর আমি বলবো, but before that I pass to my colleague Barrister Genevieve Moss to talk more on stop and search. Please, Genevieve.
Thank you. We've just covered what the police have to make a record of when they stop and search you. I'm now going to talk about what a police officer has to say to you when he stops and searches you. Now, the acronym that police officers are taught when they are training is go wisely. It's a good way to remember all the things that they're supposed to say to you when they stop and search you. I'll go through those in turn. So go, G stands for grounds. They have to tell you why they think you have something that you shouldn't have. O is the object of the search, so what they're looking for. And then wisely. W is warrant card. They must show this to you if they're in their plain clothes, and if they're in uniform, you still have a right to ask to see it. I is identity. They should tell you their name, and S, station, so the police station they're attached to. E is your entitlement to a copy of that search record we were talking about. And L is the legal power, so they have to tell you under what provision they are searching you. And there are various powers of stop and search, and they're all listed in Code A, Annex A. You can have a look at the code just by Googling it if you want, and have a look through all the different powers that the police have. Y is you. So that's where they inform you that you're being detained for the purposes of a search. So go wisely is a useful acronym just to remember the things that they need to tell you. Where can the search take place? Well, it must be at or near the place where you or your vehicle's been stopped. And this means reasonable travelling distance. So whether you go on foot or by car, you can't go too far away from where you've been stopped. And remember that the power only applies if you are in a place to which the public has access. So the police can't enter your home or any other person's home under Section 1 PACE for the purposes of stop and search. They could stop you, for example, at a railway station or on the tube, because they can stop you in a place where the public has to pay to gain entry. But if you're in a garden or the yard of anyone's home, the police can only stop you for a search if they have reasonable grounds for suspecting that you shouldn't be there. So either you don't live there yourself, or you don't have the permission of the person who does live there to be in the yard or garden. What are the police allowed to ask you to take off or remove for the purposes of a search? Well, this is where another useful acronym comes in, JOG, J-O-G. The constable can require you to remove your jacket, J, any outer garments, for example, scarves, hats or backpacks, that's O, and your gloves, G. You can ask, they can ask you to take off more items in public voluntarily, for example, a jumper, but there's no power to require you to do so. So you don't have to take it off if you don't want to. Just your jacket, outer garments, and your gloves. Now, if the police want to conduct a more thorough search, the search is regarded as an intimate search, and they have to do so out of public view. So you may be taken to a police station or another suitable private place, such as a police van. But remember, you must still be at or near the place where you were stopped, within reasonable travelling distance. And what about the removal of face coverings? There's no power to stop and search for disguises, but Section 60AA of the Criminal Justice and Public Order Act 1994 confers a specific power on police to demand the removal of disguises, but only in certain specific circumstances. If the officer believes that an item is being worn wholly or mainly to conceal identity, he can require you to remove it, and he can seize the disguise, but he requires the written authority of an officer of the rank of inspector or above. And the circumstances in which such authority can be given are restricted, and the authority will only last for 24 hours. So normally, if you cover your head or your face for religious reasons, and this has the side effect of concealing your identity, that's not enough reason for an officer to ask you to remove the item. He must have reason to believe that you are wearing it wholly or mainly to conceal your identity, so for the purposes of concealing your identity rather than for example, religious reasons. And if the officer has such grounds and such authority, he should allow you to remove the item away from public view, in the presence of an officer of the same sex as you, and out of the sight of anyone of the opposite sex. How long can the police detain you for the purposes of a stop and search? There's no set time, but it must be a reasonable length of time, and it has to be kept to a minimum. And how thoroughly can the police search? Well, the extent and thoroughness of the search cannot be excessive. They can only search insofar as it's necessary to find the items that they have said they're trying to find. So if they're looking for a hammer, it's not appropriate for them to search through your purse or wallet, or to ask you to take off your gloves. But if they have reasonable grounds for suspecting that they'll find a small wrap of cocaine, for example, then they can indeed search to that extent, and it won't be excessive to ask you to take off your gloves or to look inside smaller compartments in your bag. Similarly, if the police officer only has reasonable grounds for suspecting that you are concealing something in a specific place, like your pocket, for example, the search must be limited to that pocket. So, for example, if a police officer just seen you put something in your pocket that he thinks you shouldn't have, he can only check the pocket. He can't go on and check the rest of you, because he doesn't have reasonable grounds for thinking you've got anything else that you shouldn't have. Remember that all stops and searches must be carried out with courtesy, consideration, and respect for the person concerned. Can they handcuff you? Are they allowed to use force? It's a very important question, this one. And the police are obliged to seek your cooperation before resorting to force or handcuffing you. So even if you initially object to the search, they should try to persuade you to cooperate, and they're only allowed to use force as a last resort. The constable can handcuff you if they detect a threat of injury, but they must be able to justify this decision. Section 117 of PACE allows a constable to use reasonable force, if necessary, to exercise any power under PACE where they don't need your consent or the consent of anyone else who's not a police officer. So if they have reasonable grounds to stop and search you, and they've gone through Go Wisely, then they're allowed to restrain you if you try to resist the search. And they can put handcuffs on you if they feel threatened, but this must be a last resort, and it must be necessary, and they can only use reasonable force. What happens if they find something on you? Under Section 1.6, the police can seize anything they find that they have reasonable grounds to believe is stolen or prohibited. And they can seize anything that is evidence in relation to an offence, but they need reasonable grounds to believe that the seizure of the item is necessary to prevent it being lost, stolen, or destroyed. So they can seize items that they find in the course of their search, which were not the subject of their original search. But it has to be necessary to seize those items to protect that evidence. If they do find something on you, then what happens next? Well, they should caution you. As soon as a police officer searching you has grounds to suspect you of an offence, they need to caution you. You may be familiar with the usual wording of the caution from, for example, TV shows and films. The words are, you do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later rely on in court. And anything you do say may be given in evidence. Those words are often said very quickly, and you may not necessarily take much notice of them as they're being said, because it's a rather upsetting situation. But they are really important, because once you've been cautioned, if you choose to remain silent, especially once in the formal setting of a police station interview, then in certain circumstances an adverse inference can be drawn from your silence. But similarly, anything that you choose to say might be used against you in any subsequent prosecution. So you really should think very carefully before you say anything and seek specialist criminal legal advice at the earliest opportunity. Bear in mind that police don't have to say the exact words of the caution in the normal order, so as I've just said them, but they do need to convey the meaning of the caution, so they can change it a little bit so long as they get the message across. Most officers will say those exact words just to make sure they cover everything. But if the person being cautioned doesn't appear to understand the caution, then the police will then go on to explain it in their own words. They don't need to arrest you to caution you. They should caution you, as I've said, as soon as they suspect you of involvement in a criminal offence. It doesn't necessarily mean you're under arrest if you hear those words. They need to caution you again before any interview. An interview for these purposes has a very broad meaning. It means before asking you any questions about your involvement or suspected involvement in the criminal offence. So it's whether on the roadside or in the police station, the police need to caution you again before asking you those questions. I can go on to talk about powers of arrest now. If there's more time.
You can continue on the powers of arrest,
Thank you. A lawful arrest will require a person's involvement or suspected involvement or attempted involvement in the commission of a criminal offence, and the officer must have reasonable grounds for believing that the arrest is necessary. You must have both elements. The arrested person must be informed that they've been arrested, even if it's obvious, and they must be informed of the grounds for their arrest. There's no requirement for the officer to give you a verbal warning about your behaviour before arresting you, but often they will give one. If you're going to be arrested, then the officer, as with stop and search, must make a record of the arrest. He must make a record as soon as possible, and specifically, he needs to record the nature and circumstances of the offence leading to the arrest, the reason or reasons why the arrest was necessary, the fact that he's given you the caution, and anything said by the person at the time of arrest. On arrival at the police station or after being first arrested at the police station, you must be brought before the custody officer as soon as practicable, and that's the point at which a custody record must be opened. Now, the custody record is a very important document. It serves as a record of your time in police custody. It should contain details of everything that you've had to eat and drink, any medication or medical attention you've received, and your interactions with officers, even when they just check on you in your cell and you're asleep. It should have all those details logged in there. And you're entitled to as of right to a copy of your custody record, and indeed to inspect the original document as well. What are your rights if you find that you have been arrested? You have a number of rights. The most well-known one, perhaps, is the right to free legal advice. That right can be qualified in some circumstances. You have the right to consult the PACE codes. That's what I've been talking about earlier on. So it demonstrates just how important those codes are. You have a right to inspect them and have a look through to make sure that the police are treating you as they should be treating you. You have the right to inform someone of your arrest. So it's not just one phone call, but within reason you can keep trying until you get through to someone, because you may need to let a loved one know that you've been arrested. You have a right to medical attention if you feel unwell. And importantly, you have a right to receive a written notice informing you of all of your rights. So that must be either written in your own language or translated to you by an interpreter. As I indicated before, there are circumstances in which legal advice can be delayed by up to 36 hours in investigations into indictable offences, so more serious offences. And this requires the authorisation of a superintendent, senior police officer. Those circumstances are to prevent interference with evidence or harm coming to a person, or to prevent you from alerting other suspects or hindering the recovery of property. And where you're waiting for a solicitor's arrival would cause unreasonable delay to the investigation, or where the arrested person has refused to see the duty solicitor, so the solicitor who's available there in the police station or available to come out to the police station to see you, but wants to see his own lawyer. Of course you have a right to choose your own lawyer, but it may mean that there's some delay in getting that legal advice you need in the police station. Remember that if you haven't seen your lawyer yet, you still have all the other rights that are contained in the PACE codes and the ones that I've spoken about just now. And you can ask for a copy of those rights in your own language, and you can inspect the PACE codes. So no need to be memorising them as we speak, but if you ever find yourself in this situation, just ask for a copy of your rights. And of course, you're entitled to maintain your silence. And it may well be wise to do so until you've had the chance to speak to a lawyer. The next section is on powers of entry. Shafi, should I go on to powers of entry at this stage?
Yeah, you can.
Very well.
Yeah.
So, PACE Code B, as I mentioned at the very beginning of the first segment, deals with circumstances when the police can enter premises. There are many different circumstances in which police can enter, and sections 8 to 16 of PACE deal with the various search warrants that the police can execute. But perhaps the most pertinent to you at home, the things that you might be concerned about, are the circumstances in which police can gain entry to your home without the need for a warrant. There are some circumstances. They have powers to do that, both before arrest and after. That's either your arrest or someone in your household's arrest. I've personally dealt with both those situations in my own cases where assaults against police constables were alleged, and the defence has been that the officers were acting outside their duty. So the PACE Code B can be a very useful tool at that stage when cross-examining police officers. The two sections of PACE that deal with entry into premises without a warrant are Section 17 and Section 18 of PACE. They provide for all the situations when police can enter your home without a warrant before you or anyone in your household is arrested. And Section 18 comes into play after you or someone in your household has been arrested. So Section 17 is before you've been arrested, and Section 18 is after you've been arrested. It's worth going through Section 17 in some detail. I'll start to do that. I think we've got some time before the next break. So Section 17 deals with entry for the purposes of arrest, etc., is what the Act says, rather helpfully. Subsection 1 states that subject to the following provisions of this section and without prejudice to any other enactment, a constable may enter and search any premises for the purposes of executing a warrant of arrest issued in connection with or arising out of criminal proceedings, or a warrant of commitment issued under Section 77 of the Magistrates' Court Act 1980, or for the purpose of arresting a person for an indictable offence. So that means a serious offence that can be tried in the Crown Court, or for the purposes of arresting a person for an offence under, and it gives a great long list of the various acts under which there are criminal offences which allow police to enter your property to arrest you if they think that you're, if you're a suspect in one of those criminal offences. So what are those offences? Well, it's any enactment contained in sections 6 to 8 or 10 of the Criminal Law Act 1977. That means offences relating to entering and remaining on property. Section 4, Public Order Act, which means fear or provocation of violence. Section 4 of the Road Traffic Act, which is to do with driving under the influence of drink or drugs, and Section 163 of that Act, which is to do with failure to stop when required to do so by a constable in uniform. If you're involved in offences relating to drink or drugs under Section 27 of the Transport and Works Act, they have the right to enter. Or failure to comply with an interim possession order as well gives them the right to enter. It's worth noting that if they are going to enter your property for the purposes of enforcing an interim possession order, the officer has to be in uniform. He also has to be in uniform if he is entering your property for offences to do with entering and remaining on property unlawfully. And finally, he must be in uniform if he's entering your property where to arrest you for squatting in a residential building. There are many other situations there where the officer can enter and arrest you, but he doesn't have to be in uniform. And as I've said, they're all stated quite clearly in Section 17(1)(b) of C of PACE. So do have a look.
থ্যাংক ইউ জেনেভিভ। দর্শক, আমরা একটা শর্ট ব্রেকে যাচ্ছি। ব্রেকের পরে আমরা আবার ফিরে আসবো। আমি সলিসিটর শাফিউল আজম, প্রিন্সিপাল অফ আজাম অ্যান্ড কো সলিসিটরস, এবং আমার সাথে আছেন আমার কলিগ ব্যারিস্টার জেনেভিভ মস। সবাই আমাদের সাথেই থাকুন।
আপনারা দেখছেন ক্রিমিনাল জাস্টিস।